So what I'm going to do is just sort of run through very quickly some of the issues that arise on enforcement, looking at some of the constraints on enforcement, COMI director duties, impact on the Waterfall, Cram downs, and some tax issues. And I thought I'd look just very briefly at some specific German-related issues. Clearly one important point is that it's far more difficult to enforce loans in Europe than in America and the UK, and that's partly through a process of just borrower-friendly legislation, requirements to go through the court in certain cases, auction requirements, court-appointed insolvency officers and certain things. So depending on the jurisdiction, there can be quite significant delays in the process of enforcement, which is why some lenders try to enforce above the local level, perhaps by selling at a Luxco level. Sometimes that works, but it also gives rise to its own complications. So as we discussed earlier, we have quite often in this sort of case much more of a consensual approach, funding of discounted purchase options, i.e. borrow, buy back of the loan. And the lender often is in a position to do that, the new lender, because it's got a different acquisition cost, no legacy relationship, etc. But it does make it slightly difficult when you're looking at these loan portfolios. What assumptions do you make from an IRR perspective in terms of your hold period and exit? So turning now to enforceability, clearly the first issue the lender needs to consider is what is the cost of enforcement? Is there going to be an impact on the business? Could it impact on the goodwill of any underlying operating business? Will it impact on value? In certain cases, a bank may try to just orchestrate a sale by the borrower as part of a consensual arrangement, sometimes with the management re-incentivised as part of the disposal process. And they may put in some of their own directors as a way of subject to certain concerns about duties, getting greater control over the company without actually enforcing security. If you get into an enforcement, what are the arguments that arise? Well, a borrower may sometimes argue that the bank has waived an event of default through its conduct or has been stopped. It's actually very difficult to do that through conduct, and normally banks send through reservation of rights letters to preserve their position. But there are arguments that can arise in certain cases. Again, an argument that borrowers not uncommonly raise is that there's been bad faith by the bank, or that they're exercising their powers for some improper purpose. And although, again, it's hard to maintain those, in the European courts, you've got more scope for arguing those sorts of issues. And there is a slight trend in some of the European courts for sort of anti-bank decisions because they're associated with the credit crunch, which was all borrowers try to leverage off in some of the initial discussions. Clearly, as a lender, you need to see whether your loan's been originated or you're outside the hardening period. A lot of loans in jurisdictions can be set aside if there's intervening insolvency within an agreed period of time, subject to various conditions being satisfied. So one analysis is what is the integrity of that underlying security. Again, in certain jurisdictions, you may find so-called springing mortgages, which was like a deferred mortgage being created to actually hopefully avoid registration duties or local transfer tax. And so the bank, particularly, for example, in Spain, might have a right to call for the security or to perfect the security, but may not have perfected it. That was quite common in 2005, 2006 and 2007. And there can be complications of enforcing those obligations once there's an insolvency event in relation to the borrower. Another common issue is that there are deficiencies quite often in documents. There's a lot of legacy issues in some of the deals that were done, particularly 2006, 2007, banks overtrading, rolling out standard documents not properly conformed. And it's not uncommon for a borrower to be able to identify some point of leverage vis-à-vis the lender through some lacunae in the bank's protections. And obviously, if you're buying a portfolio, you need to be very careful, try and assess the scope of that. Against this sort of framework, there's also changing case decisions. I'll just mention one very briefly, Eurosale. This looked at basically the definition of when does an entity become insolvent. And in the Insolvency Act, there's both a cash flow test and can be as well as an alternative a balance sheet test. And Eurosale test said that you only fail the balance sheet test where you've reached the point of no return, i.e. that it's quite obvious that you're going to go under. But very recently, the last week or so, that's been overturned by the Supreme Court here, which says that you need to sort of look on a more prospective basis forward based on assumed probabilities and outcomes. So let's just turn now to COMI. COMI is the centre of main interests, and this is where the entity is most closely associated. And the significance of that is that the insolvency law applicable to an entity will be governed by its COMI, not necessarily by its place of where it was established. So although there's a presumption that its COMI is where its registered office is, that can be rebutted by a number of situations where its actual operation is, where it's entering into its main contracts, even what form of accounting principles it's using. So a whole series of things are taken into account to assess the COMI. So one issue that sometimes arises is that the borrower will try to orchestrate its own affairs to change the COMI into a more borrower-friendly jurisdiction. And, for example, a jurisdiction that has administration, or a jurisdiction where there may be more friendly set-aside provisions. So that is an argument that will quite often arise in the context of negotiations with a bank. Clearly there's sensitivities from a tax point of view in that you don't want to change the residency of the company, but often in this situation tax is irrelevant at that time. No one's making a gain, so it becomes less of a relevant issue. There is a general provision that COMI doesn't apply in relation to what's called rights in rem. So on one level, COMI won't impact on the enforceability of security, but the application on that on a jurisdiction-specific basis is pretty unclear, and it sometimes gets overridden by local administration principles. Another issue that's always relevant and sort of affects decision-making and behaviour is the sort of scope for director duties. One sensitivity here is for the banks, and they're obviously concerned to ensure they don't become a shadow director with potential liabilities. But also from the directors of the borrower, in certain cases they can be liable for what's called wrongful trading. At the point where the company is becoming insolvent, their primary duty switches from the shareholders to the creditors. So there's quite a lot of sort of grey areas there as to what is the proper action for a director to take when it's potentially going under a loan. And what we sometimes see is a lot of nervousness, particularly amongst administrative directors, who are concerned about their own liability, which can lead to an element of paralysis of decision-making or even accelerated resignations by some people. Occasionally that resignation is used as a negotiating tactic with the bank, because obviously the bank don't want to have an SPV vehicle with no directors. This partly locks back to COMI, because COMI, obviously, if you change the COMI, you're trying to prejudice the lender, the creditor's position. But as a director, your duty switches to the creditor once you are or are likely to become insolvent. So sometimes, although it may be in the interest of the borrower to change the COMI, there's that additional sensitivity for directors. Clearly also the waterfall needs to be analysed depending on your cash flow assumptions. Are you assuming on your return that you're getting some income through? Are you assuming that your loan is going to be amortised down and that therefore your risk profile from a value perspective will be reduced? So all the sort of stop events that can arise for an intervening insolvency event or cash traps need to be considered very carefully, plus also any express contractual or mandatory under local law provisions where further advances made into the borrower have automatic priority, so-called debtor in possession financing. Other issues, we discussed earlier about swaps still being a problem based on duration, the mark-to-market value. In a CMBS situation, the swap liability has super senior priority over the loan. That's less common in a straight loan situation, but does need to be reviewed on a case-by-case basis. Also, you need to look at the voting rights. Sometimes the way the documents work, the amount by which the swap's out of the money is added and aggregated for the purpose of computing the voting rights of the bank, which probably wasn't the original intention, but nevertheless can be sometimes how the wording works. If we're looking at a debt for equity swap, then again, in certain cases you need to see whether you can push that through based on the constitution of the company, shareholder provisions, articles, etc. In a number of cases, it's actually quite difficult. Then again, you need to consider change of control provisions. Is that going to impact on material contracts, give rise to any termination events? So all these sorts of issues would need to be taken into account by the lender. Again, just two others there. Confidentiality. There is this issue about if to what extent can a bank share confidential information relating to a borrower, which can be particularly sensitive if you've got listed debt, where if information is provided, you could get into insider trading issues where you can't sell your bonds or listed loan notes. And that sometimes does impact on the whole process of having a meaningful dialogue, because there needs to be a dialogue, but certain holders of debt won't want to have too much information that prevents them from selling down the debt. One other thing, just general thing here to mention, is the whole bank licensing issue. In the UK, you don't need a bank license unless you're originating loans to individuals. But in Europe, in a lot of jurisdictions, that's not the case. And sometimes in certain jurisdictions, either by varying the loan, or even if you novate the loan as part of a restructuring, which takes effect as low as a new loan, you bring yourself within local banking license requirements. So it's very important to identify where those apply. There's usually a way of structuring around it, but it needs to be layered into the process. Cram downs, again, sort of a relevant part of the underlying process. Useful particularly where you've got a recalcitrant or difficult minority investor, perhaps someone who's bought a loan is trying to be difficult to be bought out at a premium to his acquisition cost. You may try and use a cram down mechanism just to override them. Equally, you may buy a position thinking you've got a majority position and then find that becomes more difficult. The two mechanisms usually used in the context of the UK are the company voluntary arrangement, the CVA, or the scheme of arrangement. In the context of security, scheme of arrangement is far more common because a CVA is not binding on a secured creditor. So the only mechanism you can really go down is a scheme of arrangement. Interestingly, scheme of arrangements can be applied to non-UK entities if they're deemed to have a UK connection. And a UK connection for this purpose is satisfied if you've got a UK asset or even if you've entered into a loan agreement governed by UK law. So it's a very loose test. So there have been a number of situations where overseas entities, as part of a process of cramming down investors, have sought to bring themselves within the UK scheme of arrangement process. For example, a very recent example was a Grande CMBS securitisation where that process was used to get the reconstruction proposals through. Pre-packs, I just mentioned this context very briefly. I'm not going to comment on pre-packs more widely, but we have seen in one or two cases pre-packs used as a way of dealing with a sort of difficult investor. But that is a complicated process because clearly you need to get the security trustee sufficiently comfortable to call an event of default, and they may have a concern if there's a creditor there who doesn't want that event of default called at that time. Just very quickly, tax. We find tax is a relevant issue in these situations. I mean, a position that sometimes arises, particularly with high net worth syndicates, is that they've done a deal and they've optimised the capital allowances, so there's a potential leverage for the bank or the acquiring lender. That if they enforce their security in a particular way, they can trigger a clawback for the investors of all those allowances, which can be quite a big number, depending on the profile and the size of the property. And sometimes banks try and leverage off that to try and get the borrowers to put some further equity in. And there's various ways of addressing that and dealing with it. A prudent borrower can sort of pre-structure to prevent the bank from doing that. And sometimes the borrowers do a separate deal with someone buying in the loan. So they take the loan off the bank, but they agree with the purchase of the loan that they won't enforce in that way as part of some wider deal. Withholding tax, I've mentioned the impact on cash flow, and that's obviously you need to assess to what extent that's going to apply to you, and you may not be the original lender but a subsequent lender, and whether you need some treaty clearance, so there might be some timing issue on the payment through. And obviously transfer tax on exit is another important issue. As a lender, you want to try and optimise your disposal in a way that minimises any transfer tax. Just quickly in terms of sort of complications that can arise when debt's forgiven as part of an overall enforcement sale. This is quite a difficult area, but there's a number of different scenarios that can arise. For example, if a bank has impaired debt, i.e. not actually forgiven the debt vis-a-vis the borrower, but written the debt down, and then subsequently becomes connected with the borrower, then there's an automatic tax charge within the borrower in the amount of the debt that was impaired. Now, bank can become connected with the borrower if it takes excessive shareholding rights, or if it leverages up its rights in the loan agreement beyond those that would be normally included. So when a bank's dealing with a borrower, they have to be very careful that they structure their arrangements in a way that don't give rise to this tax charge on the amount of the impairment, because quite often they're going to be exiting by selling the underlying vehicle, particularly when that vehicle holds an operating business. And it's not always the case that the banks have done that. Again, just the whole concept of forgiving debt, that may... Quite often, if a bank is exiting, the quantum of the debt exceeds the purchase price. So part of the debt needs to be written off, and the forgiveness of that debt in itself can trigger a tax charge. So there needs to be structuring layered on to exclude that liability. And again, there are ways of doing that. That can be through a debt for equity conversion and the equity included in the shares that are sold, or the debt can be re-tranched into two separate loans, part of which is novated up outside the group being sold. But it's very important to make sure that's properly integrated into the process. I thought I'd just end just very quickly to take one example of an overseas jurisdiction, just to sort of run through some of how the dynamics there differ from the UK. So to take, by way of example, Germany, that is subject to an auction process. There are particular rules that apply if the auction price is less than 70% or 50% of reserve prices, etc. Also, Germany has its own concept of an actionable event of default. So your contractual documentation may set out clearly the events of default, but if they don't fall within certain generic criteria in the German Civil Code, it wouldn't necessarily follow, depending on how the loan agreement's been structured, that the loan would be actionable. Germany also has this concept of equitable subordination, which you see in a number of German jurisdictions, whereby a shareholder debt, but also a mezzanine debt, and in certain cases a senior debt which has unusual provisions in it, can be treated effectively as equity and therefore subordinated in the waterfall to other creditors. And that really requires analysis of the loan as to whether it can fall within those categories. Again, at a certain point, a trustee needs to be appointed to a German entity trustee in bankruptcy, but they're very reluctant to do that whilst the debt exceeds the value of the assets. So as part of that process, a trustee in bankruptcy in Germany would normally say the debt should be forgiven. Unfortunately, that can trigger a tax charge in Germany unless you get a dispensation. So people sort of try to get confirmation from the revenue authorities that there won't be an imputed tax charge, but that process impacts on the timetable for enforcing security. Just two other things as part of an illustration of how the consensual process, which we've discussed, works in Germany. I mean, a purchaser of a loan in Germany would quite often go to the borrower, do a deal with the borrower and say, well, look, I will give you a period of time to implement a business plan, but you will give me up front a perfected power of attorney so that at the end of that period I can then enforce without any problems. And that's a very common sort of mechanism. And one other thing, and again, we're seeing this in a number of European jurisdictions where they are trying to modernise and improve their insolvency local legislation in a way that introduces more flexibility. So in Germany, for example, there's been 4 changes recently, all of which move it slightly more towards a Chapter 11 administration type process. Firstly, in certain cases, there's mandatory priority for debtor in possession funding. So if a lender comes in and actually puts more money into the business to keep the business going, that will be leveraged up in the waterfall. Again, debt for equity conversions in Germany were effectively impossible if they were blocked by a shareholder. But now there's a mechanism called an insolvency plan where that shareholder can effectively be crammed down and forced to accept that. Again, they've introduced the provision of an initial committee for creditors, which is important for 2 things. A, the creditors can get involved when the process of insolvency starts, but before it's been fully implemented. But also they can have a strong say, or they don't have final choice, in the identity of the insolvency officer. Previously, it was a German court who decided which the insolvency officer was, and that was often part of some wider local relationship, which sort of complicated the whole enforcement process. And they've also introduced something, a sort of quasi-type administration process where a borrower can have a period of 3 months to come up with a proposal, and during that period no one can enforce any security. So it's a bit like administration, but it's only for a fixed period of 3 months, and unlike administration or Chapter 11, it can only be implemented once you have become insolvent. So it's not the full range, but it's this is a modification from the regime that used to apply there.